So what happens if someone infringes on your copyrights, either in your sound recording or your composition? In other words, they use portions of your prior copyrighted work. Well, if you think that they've infringed on your rights, you can certainly send a notice and file a claim. And at some point, if you have a U.S. copyright registration, you can sue them in federal court. However, I want to let you know that suing people for copyright infringement and proving the case isn't an easy thing to do. Because if you go to court, you're going to have musicologists that are going to testify on both sides, and they're really going to notate each song and really compare to see how close that song comes or that sound recording comes to the other. And that can be a very difficult process. As a matter of fact, most copyright claims are usually settled before there's a decision in the case. A lot of people also ask me, well, I've heard about this rule that if you only use 4 bars of somebody else's song or sound recording, then it's not considered copyright infringement. False. It could even be 3 notes. The NBC television network used to have a 3-note sound logo that they used to play at the top of every hour. Now, I can't repeat those notes here because I don't want to infringe on their copyright. But if I did or anybody else used those 3 notes, the NBC network could sue them for copyright infringement. So if you feel that your copyrights have been infringed upon and you have U.S. copyright registrations, you're in a position to sue in the U.S. federal court system. And once you get to the case and get to the trial level, there are 3 elements of proof. 3 elements of proof, and this is the reason why I say that proving copyright infringement is really no joke. It isn't as easy as everyone thinks. Many times people will hear songs and they'll say, that sounds just like this song. That person should sue that person for copyright infringement. And they fail to recognize that there are 3 elements that you have to prove, and it might be difficult overcoming some of those hurdles. Let's talk about the first element of proof. 1, you have to prove that you actually have a U.S. copyright registration. As I mentioned earlier, you have to bring that copyright registration to court. So make sure that you carefully catalog your copyright registrations. 2, you have to prove access. You have to prove that the person that infringed on your work had access to your copyrighted work. They heard that work before, and that's the reason why they created their work incorporating your work. Access isn't that easy of a thing to prove. Certainly if you went backstage with an artist and you played them a song and there were other people in the room who could testify that the artist heard that song on that particular date, and then 3 months later the artist comes out with a song that sounds just like your song, but they didn't get permission from you, that's a pretty easy case of proving access. However, it usually doesn't happen that way. You don't have to have just direct evidence of access, however. In some cases, you can prove access through circumstantial evidence. In other words, you can prove that an artist that infringed upon your work had listened to the radio stations that your song had been played on, and therefore must have had access to your song. So access isn't as easy as it sounds to prove. I had a client that came to me and said, Mr. Kellogg, Stevie Wonder stole my song. Stevie Wonder stole my song. So I said, well, okay. But knowing that I had to prove access, I said, but how did Stevie Wonder hear your song before creating this other song that you say infringed on your song? And he said, well, I sent it to Motown. I sent it out to California and I sent it to Detroit. And by that time, I knew that record labels and publishing companies had stopped taking unsolicited material. And this is the reason why they stopped taking unsolicited material. And by that I mean they will only take material from people that they know, talent agents or lawyers that they really have good relationships with. So you aren't going to find the kind of situation that just because a song you hear on the radio sounds something like your song, then there's copyright infringement. No, you really have to prove that the person that you claimed infringed on your work had prior access to your work and developed their work based on your work. So I turned that case down. The case eventually went to trial. They couldn't prove access, and they lost the case. And as I said before, the judge in a copyright infringement case can order the losing party to pay the winning party's attorney's fees. And in this case, the judge did indeed order that potential client to pay Stevie Wonder's attorney's fees in the amount of $240,000. So as I indicated before, copyright infringement cases aren't as easy to prove as a lot of people think. So you have to be very careful because you could be ordered to pay the attorney's fees should you lose the case. All right, the elements to prove a copyright infringement case. First, you have to have the copyright registration. Second, you have to prove access. And the third element is substantial similarity. You have to prove that your work was infringed upon and the other person that created a work that infringed upon yours is substantially similar to your copyrighted work. Substantial similarity is determined on a case-by-case basis. And as I alluded to earlier, each party is going to have their expert, usually a musicologist, that's either going to try to prove that the song is similar or that it isn't similar. And that's going to really be determined by either the judge or the jury. So there is no set formula to determine substantial similarity. It's really going to come down to the evidence that's presented by both of the parties and the determination that's made either by the judge or the jury. However, if the two works are strikingly similar where anyone can hear that the music is really the same, then you don't even have to prove access in order to proceed with a copyright infringement suit. I remember having one client's song used, I felt a certain portion of their song used in another popular artist's song, and I raised this issue to the publishing company that administered the songs on behalf of my client, and to me it really sounded like copyright infringement. Well, the publisher was smart. The publisher hired a musicologist to actually notate the rhythms, the melodies, and the lyrics to determine whether or not it was enough to move forward, whether or not it was substantially similar or not. Although I disagreed with the publisher, I had to go along with their decision because they are experts in that particular area of determining whether or not it's worth going forward with a copyright infringement claim.